Hey, welcome to today's video. I'm Rick Chappell with DMCAAgentservice.com. So today we're talking about a copyright issue, specifically how to copyright a phrase or slogan. I have some good news, and I have some bad news. So the good news, let's start with, well, actually it's the bad news. Let's start with copyright. What is copyright? Well, people like to get themselves twisted up trying to define it. I think the easy way to remember it is simply to say it's a creative work of authorship. And so let's use an example. J.K. Rowling, she writes another Harry Potter book. Okay, well, that's going to be 600 or 700 pages. It's her plot. She's come up with something, specific to her storyline. She's writing the actual sentences, putting that together. I think we can all agree that's a creative work. Now, one of the questions that comes up in copyright is how much work do you need for it to be creative? So can one word be considered a creative work? Well, in some esoteric art circles, probably, but for the rest of us, the answer is no. And so we have a rule in copyright law that says if the work is of insufficient size, it cannot be copyrighted. And when we're talking about a phrase or a slogan, that would mean X number of words. And you're probably thinking, okay, well, how many words does it have to be before you can copyright it? And the answer is there's no specific amount. Instead, they're going to look at the content that you submit to see, if it rises to the level where it's a creative work. So let's use an example. Let's say the phrase "just do it." Let's say J.K. Rowling includes that phrase in one of her novels, and she files a copyright for it. And I realize she never would do this, but let's just use it. Is the Copyright Office going to allow her to copyright that phrase? And the answer is no. And the reason being, well, think of all the millions and millions of other novels out there. More than a few are going to have a situation where two characters are talking to each other. One gets mad at the other and says, just do it. It's probably going to be a parent talking to a child. But there are going to be all these examples out there. Now, are we going to say that J.K. Rowling has the right to claim all those other novels are infringing because they're using that small phrase? No, it would be insane. We would ultimately end up with almost no books. And so with copyright, we're looking for a much more substantial amount of content before we're going to give it that kind of protection. Now, does that mean you're screwed? No. The solution with a phrase or a slogan is not to file a copyright, but to file a trademark. And a trademark is simply some type of a mark, such as a phrase or a slogan, that identifies a good or a service. And so if we go back to Just Do It, well, Just Do It is a trademark of Nike. And when you hear that phrase and associated with sports apparel, well, you know that that's associated with Nike, their shoes, their clothes, what have you. And so it is an identifier in that sense. You can also have service marks. So trademarks are traditionally for companies or goods, and then the service marks apply to service marks or services. So if you think of like HR Block, who helps people with tax returns, they provide a tax return service, they would get a service mark. Under trademark law, trademarks and service marks are the same. All the rules apply to both, but it's just important to make sure you understand the differences. Now again, trademarks and service marks apply to short expressions. If J.K. Rowling tried to trademark her new novel, all 700 pages, the trademark office would reject it and probably be laughing as they did so. Now, there's an important distinction between copyright and trademark that you need to understand. With a copyright, once the work is completed, copyright automatically applies. So when J.K. Rowling finishes the final version of her novel, it's there, it's ready to go. Trademark applies. She has a common law trademark. Now she needs to go ahead and register that copyright with the Copyright Office because she's going to gain more protection there and a lot more rights. But she has it once she's finished the work, once she's completed the novel. That's not true with trademarks. So let's say you're sitting around one day and you're trying to come up with a slogan for your business or your company or what have you. And you eventually decide on one and you write it down and you say, okay, this is my slogan. This is my trademark. Well, trademark, that's not a trademark. It doesn't apply there. You have to use it in public. So you have to actually go out and use it in commerce as part of your advertising or sales, or you need to sell a product with on it, something of that sort. So there's that extra step. And you can actually file something called an intent to use application with the Trademark Office. And what that basically says is that, exactly as the title suggests, you intend to use it sometime soon. And you have 6 months to get it into commerce. Now, when you file it, that date is important because if you then subsequently do use it in that 6-month period, the Copyright Office will backdate the first use to the time when they or to the date that they received the intent to use application. So basically, with Trademark, a big issue is who uses it first. So that's a way to kind of get some extra time, but also get it backdated and protect yourself. Probably goes beyond the scope of this video, but just keep that in mind. So how to copyright a phrase or a slogan? Generally, it's pretty difficult. There can be a few exceptions. The only one that really comes to mind would be if you have a series. In some situations, the Copyright Office will allow for you to file a copyright. So, for instance, books. You're often told book titles cannot be copyrighted. Generally speaking, that's true. However, if you file a series of books, in that situation, they will often let you copyright the titles. So, for instance, the Dummies books, Dummies for Windows 10, Dummies for Greeting Aliens, Dummies for this, Dummies for that. Okay, well, in that situation, the Copyright Office will allow for copyright title to be filed for those titles. Even then, though, you're asking for a legal fight. You're asking for lawsuits to contest whether it should be allowed or not. If you're going to go that direction, talk to a lawyer. Make sure you have a good plan in place. And again, a trademark's still probably the better option, just because trademarks are, in my opinion, even stronger than copyrights, and they can really carry significant damage claims if somebody is violating and infringing on your trademark. But anyways, there you go. How to copyright a phrase or slogan. If you have questions or comments, post them below. I'll be happy to answer them. Otherwise, have yourself a good one.